My name is John Villanueva, and this is Disabilities in the Workplace. In this presentation, we're going to go over the Americans with Disabilities Act. We're going to go over its history, its legal terminology. We're going to go over your rights and protections under the Act. And should the worst happen, we're going to teach you what to do to protect yourself should any violations occur. By the end of this presentation, you're going to know what the ADA is and how to use it to protect yourself in the workplace. The Americans with Disabilities Act was signed into law July 26, 1990. It's divided into 5 general sections called titles. Title I has to do with employment law. That's what this presentation is mostly going to cover. Title II covers public services, and this also means state and government agencies, municipal agencies. Also covers public transportation. Title III covers any public privately owned entities, hotels, grocery stores, um, any public businesses. That's the title that's responsible for there being wheelchair ramps everywhere, for making sure that all the doors are wide enough for wheelchairs to be able to get through, that kind of thing. Title IV governs telecommunications. It mandates that there is a system in place for the hearing impaired to be able to use the telephone. Title V extends protections against threats and coercion and retaliation against anyone covered by the Americans with Disabilities Act for exercising their rights. Now, for this presentation, we're going to stick to Title I, Title II, and Title V. A disabled worker under the Americans with Disabilities Act is a worker who has or is thought to have a physical or mental impairment that substantially limits a major life activity. Now, it's important to note that the worker does not necessarily have to have that disability. Only being perceived as having that disability is enough to activate protections under the Act. Examples of major life activities include walking, talking, seeing, sleeping, learning. Activities that are specifically not covered by ADA are the ability to reproduce, or visual impairments that are fully correctable with eyeglasses, or hearing impairments that are fully correctable with hearing aids, etc. AIDS and diabetes are specifically mentioned under the Americans with Disabilities Act. Also, with drug and alcohol abuse, someone who is fully rehabilitated from drug and alcohol abuse is covered under the Americans with Disabilities Act. So they cannot be discriminated against for their former abuse. However, someone who is actively in the throes of drug or alcohol abuse is not covered under the Americans with Disabilities Act. So an employer is within their rights to take disciplinary action against an employee who, for example, shows up to work intoxicated. But under the Americans with Disabilities Act, that employer would not, say, be able to retaliate against that worker if they found out that they used to drink 2 years ago, if that makes any sense, or if they found out that they were in Alcoholics Anonymous. The Americans with Disabilities Act revolves around something called reasonable accommodations. Now, what a reasonable accommodation is a means for an employer to help an employee compensate for their disability. Now, the means for doing this is really only limited by the imagination. It can be just moving around furniture, schedule changes, specialized equipment, specialized software, extra 15-minute break, letting them lay down every once in a while, specialized desk, transfer to another position, you name it. But of course there are limits. An airline pilot, for example, no matter how exceptional the accommodations could be, could never be done by someone who's blind. Even though someone who's blind could conceivably do pretty much every other job in the industry, that one in particular could not be done by someone who's blind. Same for, say, CDL truck driver, and et cetera, et cetera. And of course, employers aren't bound to accommodate those types of disabilities for those types of jobs, of course, because they can't feasibly be done. The other way that an employer is not compelled to do so is if it would be an undue hardship on the employer. The main way that that happens is if it's too expensive, or if it would be too difficult to implement. There's not really any strict guidelines on either one of those. It's really on a case-by-case basis. But basically, the law is if an employer can do it, they should. So obviously, a smaller company is going to be held to a much lower standard of accommodating their employees, whereas a very large corporation is going to be expected to have very large resources to accommodate employees with disabilities. Now, your rights under the Americans with Disabilities Act are activated the second you are disabled. They're activated before you apply, they're activated during the application process, they're activated during the hiring process, they're activated while you work. It doesn't matter if you were disabled before you applied, it doesn't matter if you were disabled on the job, it doesn't matter if you were disabled during your off time. There's absolutely no differentiation under the Americans with Disabilities Act. If you are disabled, you are covered. The Americans with Disabilities Act applies to every company with 15 or more employees. Now, these companies are required to accommodate your disability as if you were already hired. So if you require an application in Braille, if you require a sign language interpreter, if you require wheelchair accessible facilities, or anything of the sort, they're required to accommodate you. However, it is important to note that they need to know ahead of time. They can't very well be reprimanded for not accommodating you if they didn't know. And it is also important to note that accommodations can't be given retroactively. For example, if an applicant has a learning disability and they're given a pre-employment test and they fail, they can't go to the employer and say that they need to have their test curved because they have a learning disability. Well, the employer should have known ahead of time, if that makes any sense. So if you require any accommodations, it's important to be upfront with the employer. That can be difficult, especially if you're worried about any type of discrimination, but of course that's a determination that needs to be made on a case-by-case basis. The case of the Equal Employment Opportunity Commission versus Spherion Corp., there were 2 deaf applicants that applied for entry-level assembly positions, and they were told that they would be given a sign language interpreter. So they left, and they were never contacted. So they called, and they emailed, and they called, and they emailed, and they finally got a hold of someone, and then they were told that they would not be given a sign language interpreter because of the expense. So they wound up having to take litigation action, and of course that was found in their favor because that employer failed to accommodate. Another case was the EEOC versus EchoStar Communications, where there was a blind applicant that was initially even refused an application because he was blind. Well, he took action through the EEOC, and afterwards he was given a pre-employment test. Well, it turns out that this employment test that he was given in Braille had 3 times as many questions as the normal written test. Well, obviously he went back to the EEOC, and that wound up in litigation, and of course you can't do that. He was discriminated against because he was blind. It has to be equitable. Okay, so these are 2 cases, 2 extreme examples, obviously, but they're protected under the ADA. They needed equitable treatment, and so the ADA is there to ensure that. The Americans with Disabilities Act protects you during the hiring process. It's illegal to discriminate against someone because they have a disability, if they're perceived to have a disability, or even if they've got a family member who's disabled. However, it's important to note that the ADA does not compel employers to hire someone because they have a disability. This is not affirmative action. The purpose of the ADA is to make the application process as equitable as possible. Its purpose is to level the playing field and to protect you from discrimination, not to give you an edge over someone else. While you're working for a company, that company is required to accommodate your disability. The law states that employers are required to provide accommodations to an employee who can perform, quote, essential functions, unquote, of the job. Now, the term essential functions has come under some scrutiny. There's one case, the Equal Employment Opportunity Commission versus E.I. DuPont de Nemours and Company. The employee worked at a chemical plant. She had a clerical position, and she had scoliosis of the lumbar spine. Well, she had trouble moving around, and her boss ordered a physical examination because he was worried that her walking around the chemical plant posed a danger to herself and to others. And the argument was that she could not successfully negotiate an emergency evacuation, and that emergency evacuation was an essential function of her job. Well, the case wound up going to litigation, and the result was that the evacuation was not an essential function of her job. Okay, so it's important that the terms of essential functions and non-essential functions are made clear early on to help prevent some of those disputes. Also, employers are required to provide accommodations for training. There's another case, the EEOC versus Walmart, where there was a deaf employee that was watching a training video. It was where they put a bunch of employees, in front of the video and as part of the training. Well, there was no closed captioning on this video, and there was no sign language interpreter, so the employee walked out. And he basically said, look, I can't understand what's going on, so I'm out of here. Well, to make a very long story short, he was essentially terminated for demanding a sign language interpreter. That wound up going to litigation, and it was basically ruled against Walmart that they failed to accommodate his hearing disability. Okay, so employers are required to accommodate you during training. Okay, so it's not just employment, it's not just your job, it is also your training, because training is part of your job. So it's important to inform your boss what you think your accommodations are, what they should be, because accommodations are not set in stone. It's a negotiation process. It should be in dialogue between you and your employer. You suggest what you think works best. They suggest what they can do, and you work back and forth to find what's the best accommodation for both parties. Okay, because the employer does not have to accommodate you the way you want them to. They only have to accommodate you in a way that's reasonable, in a way that enables you to do your job effectively. Okay, so it's important that there's a give and take. It's important that you make your needs known, and it's important that you ask questions, and it's important that you're honest about what you can do and what you cannot do, because it saves a lot of these troubles down the line. Now, a lot of employers, especially the smaller ones, are worried about the cost, and it might help you to tell them that the government offers tax incentives and grants, and there are some organizations that will pay for accommodations outright for certain types of disabilities. Companies are not permitted to exclude disabled workers from a promotion or a transfer. However, the ADA does not compel them to promote an employee or transfer them because they're disabled. Again, the purpose of the Americans with Disabilities Act is to level the playing field, not to give disabled workers an edge. However, it should also be noted that transfers are allowed as a form of accommodation for certain types of disabilities. It should also be noted that demotions are never allowed as a form of accommodation. Demotions are never allowed because of a disability, and in many cases, they are considered a form of retaliation. The Americans with Disabilities Act prohibits unequal pay due to disabilities. Disabled workers are entitled to the same pay as non-disabled workers for the same work. It's also important to know that employers are prohibited from trying to get back the cost of accommodations from the employee. In other words, they cannot deduct the cost of those accommodations from the employee's pay or benefits in any way. To do so is absolutely illegal and is actionable. Retaliation is strictly prohibited under the Americans with Disabilities Act. Retaliation is when an employer tries to punish an employee for exercising their rights under ADA. Potential reasons for retaliation could be reporting a disability, could be requesting an accommodation, or it could be just being disabled. In the case of Flowers versus Southern Regional Physician Services Incorporated, the employee was HIV positive, which is a protected status under ADA. She was a model employee and she had a great relationship with her supervisor. Whenever her supervisor found out that she was HIV positive, everything changed. She was shunned. She received 4 random drug tests in a week. She received an excess amount of write-ups in a short amount of time. And the whole situation devolved into a very loud altercation in which the employee was terminated. The case went to litigation, and it was ruled that the company discriminated against the employee because of her disability. Now, this isn't to say that an employee is immune from discipline if they're disabled, but it does mean that an employee's disability is to be taken into account whenever it comes to disciplinary action. Now, obviously, some disabilities don't even come into play, and this is on a case-by-case basis. However, it is the responsibility of the employer to take a disability into account if it pertains to the disciplinary action, and the courts do hold them responsible. There are many potential types of retaliation, of course: demotion, cut in pay or benefits, new job duties. In the case of Fox versus General Motors Corporation, a foreman refused to let his employee abide by light duty restrictions, and he even went so far as to assign this employee a hazardous workstation. The employee wound up having his injuries exacerbated and wound up having to quit the position because of the pain and the stress. The case went to litigation, and it was ruled that the company discriminated against the employee because of his disabled status. And of course, it can go even further to blatant harassment. And of course, someone can be terminated as a form of retaliation. There's no specific provision within ADA that prohibits harassment because of a disability. So common law applies Title VII of the Civil Rights Act of 1964, modified for the ADA. It has 5 parts. The qualified individual has a disability. 2, that individual is subject to unwelcome harassment. 3, that harassment has to be based on that disability. 4, the harassment has to be so bad that it alters the very nature of that employment. And number 5, the employer has to have known about it and not done anything about it, to put it quickly. In the case of Arrieta Colon versus Walmart stores, the employee had a protected condition and was constantly ridiculed by staff, and staff actually went so far as to do so over the intercom system. Management knew about it and did nothing to intervene, and in litigation they were found liable. So employers are responsible for intervening on the employee's behalf if there is harassment present, or they are liable. If you have a dispute with your employer about your rights or about your accommodations, how do you go about fixing it? Well, remember that employers always have a right to try to fix it before things blow up. Dialogue is paramount between you and your employer. If things start to go south, most companies have some type of internal grievance policy, usually through their human resources department. And the most common dispute with this type of thing is a disagreement on accommodations. Employee thinks they should have one thing, and employer disagrees, that kind of thing. If It does get bad to where human resources can't solve the problem. The Equal Employment Opportunity Commission does offer mediation services to help. And of course, litigation is always um, the last recourse. It's the most expensive, it's the most time consuming, and it's the most stressful. But it's also the most final. Um, Possible remedies that you could get, um, you could just receive a schedule change. You could receive a new position that's allowed as an accommodation under ADA. Um, you could be allowed to purchase specialized equipment. And remember, the government does offer assistance for a lot of these types of purchases. So remember to mention that to your employer because, again, they might not know. Um, and a lot of times courts will award back pay, what are called compensatory damages, which is, to make it up to you, and punitive damages, which is designed to punish the company for something that they've done. Those are usually for what are considered particularly egregious violations. Should all else fail and you can't resolve your dispute, it could go to litigation. Always try to settle your disputes within the company if you can. It'll save you time, it'll save you money, and it will save you a lot of stress. And also, it will help save a lot of bad blood between you and your company. Once a complaint leaves the company and goes on the public record, it can't come back. You can't take it back, even if you want to. Learn your rights, weigh your options carefully, but in the end, it's up to you to protect yourself. Just be patient, be careful, and above all, don't do anything out of emotion. For someone with a disability, the workplace can be extremely intimidating. It can be very difficult to admit that you have a disability, and even more difficult to ask for help and accommodation. But admitting that you have a disability is not admitting weakness, and requesting an accommodation is not asking for special treatment. In my experience, most employers are extremely understanding and extremely sympathetic. The cases that we talked about are the exceptions, not the rule. It's the outliers that write case law, not the status quo. So if you or a loved one have a disability, I strongly encourage you to initiate a dialogue with your supervisor or your human resources representative about finding accommodations to make your workday more enjoyable and more productive. I hope that my research to learn more about my rights has helped you learn more about yours. If you would like more information, check the bibliography section at the end for further reading. Thank you very much.